Chapter 5, Mental Capacity. Section 55, Insanity. Definition. Mental capacity is an important essential of criminal responsibility. This is owing to the fact that a mentally incapable person cannot entertain a criminal intent. In the law of crimes, this idea is involved in the definition of insanity. The books disclose great judicial efforts to reach up and grasp the definition of insanity. The results have been a discord. It may, however, in its broadest sense, be defined as any defect or disease of the mind which renders it incapable of entertaining, on which prevents it entertaining in the particular instance, criminal intent. A statute, providing that insanity shall not be a defense to a charge of crime, is unconstitutional. Section 56. Classification of insanity. Insanity, in the broad sense of the term, is divided into 4 general classes. These 4 classes are as follows. 1. Idiocy. 2. Imbecility. 3. Mania. 4. Dementia. 3 other classifications are total and partial insanity, and permanent and temporary insanity. Section 57. Idiocy. The term idiocy means the state of being an idiot. An idiot is a person having no mind, and therefore no reasoning power, and who has been a fool from his birth. A fool is not necessarily an idiot, but an idiot is always a fool. The former may intentionally violate common sense in his actions, whereas the latter is unable to do so. A buffoon is an artificial fool, whereas an idiot is a natural fool. Blackstone's definition is, an idiot, or natural fool, is one that hath had no understanding from his nativity. 4. Section 58. Imbecility. Debility. Stupidity. Imbecility is the state of being an imbecile. An imbecile is a person who is mentally or physically weak. Cases relating to imbecility often present very puzzling questions to a court and jury. Imbecility differs from debility. Imbecility is always constitutional, and pertains more particularly to the mind. Debility may be otherwise than constitutional, and always pertains to the body. Imbecility also differs from stupidity. An imbecile is very changeable in his views and very vacillating in his purposes, whereas a stupid person is very persistent in his views and in the resolutions he makes. Imbecility bears the same relation to stupidity that genius bears to talent. That which in its highest form is genius, in its lowest form is imbecility, and that which in its highest form is talent, in its lowest form is stupidity. Section 59. Mania. Intellect. Monomania. Mania, or madness, is a state or condition of the mind which renders the person a maniac. A maniac is a person who, owing to a diseased mind, has a disordered intellect which renders him insane. Intellect is a generic term. A person may have intellect without talent or genius, but he cannot have either talent or genius without intellect. A maniac has intellect, but an idiot has none. The former has a diseased mind, whereas the latter has no mind at all. Monomania is a state of madness, or derangement of the mind, with respect to one subject only. Homicidal mania is an insane impulse to kill, pyromania is an insane impulse to burn buildings, and kleptomania is an insane impulse to steal. A person, therefore, may be insane and irresponsible as to one subject and at the same time sane and responsible as to others. He may be punished unless impelled to crime by his monomania. But many courts hold that monomania, causing an irresistible impulse to crime, is no defense when the offender knew the act was wrong. Section 60. Dementia. The term dementia means loss or feebleness of the mental faculties. It ranges from mere failing memory to utter fatuity. Like mania, it is produced by lesion of the faculties subsequent to their development, whereas idiocy and imbecility result from defective development of the faculties. Senile dementia is loss or feebleness of the faculties produced by age. Section 61. Emotional insanity. Moral insanity. The so-called emotional insanity is, in reality, no insanity at all. It is merely an excited condition of the mind produced by anger, jealousy or some other exciting cause, and constitutes no defense to a criminal charge. Nor is the so-called moral insanity, which consists in a perverted condition of the moral system, produced by excessive and unrestrained indulgence in viciousness, any defense. It has been held, however, that it may reduce a homicide from murder in the first degree to murder in the second degree. This view is somewhat doubtful to say the least. Section 62. Tests of criminal responsibility. To be held criminally responsible for his acts, a person must have intelligence and capacity enough to have a criminal intent and purpose. One not a responsible moral agent is not liable to punishment for criminal acts. It is the conclusion, however, of many eminent authorities that no satisfactory test of criminal responsibility exists. The chief tests which have been recognized, at different times, are the following: 1. The child test. 2. The wild beast test. 3. The test of knowledge of right and wrong in the abstract. 4. The test of knowledge of right and wrong as to the particular act committed. And 5. The power of control test. Section 63. The child test. Since children under 14 years of age are prima facie incapable of crime, the test was proposed that imbeciles or persons mentally deficient ought not to be held responsible criminally unless of capacity equal to that of an ordinary child of 14 years. The objection is that the workings of an insane mature mind and a semi-mature one are very different. Owing to the vagueness and uncertainty of this test for practical application, it has been abandoned. Section 64. The wild beast test. This test originated with Justice Tracy in 1724. He instructed the jury that a man, to be criminally irresponsible, must be a man that is totally deprived of his reason and memory, and doth not know what he is doing, no more than an infant, than a brute, or a wild beast. This test has never been recognized in this country, and long ago became obsolete in England. Section 65. Test of right and wrong in the abstract. This test originated with Lord Mansfield in 1812. 17. It became obsolete in England in 1843, and is obsolete in this country. Section 66. Test of right and wrong as to the particular act. This test had its origin in England in 1843, and is the only test recognized in that country today. It is also recognized in this country universally, but it is not the sole test recognized here. This test grew out of the celebrated Macnaghten case. Macnaghten, intending to kill Sir Robert Peel, the Premier of England, and mistaking the Premier's private secretary for Sir Robert, killed the secretary. Upon a charge of murder, his defense was insanity. His acquittal aroused much public discussion, and the question of insanity as a defense to a criminal charge was debated in the House of Lords. Growing out of this debate, the Lords submitted certain questions to the judges. The judges replied that to establish a defense on the ground of insanity, it must be clearly proved that, at the time of committing the act, the party accused was laboring under such a defect of reason, from disease of the mind, as not to know the nature and quality of the act he was doing, or, if he did know it, that he did not know he was doing what was wrong. This test, however, is an imperfect one, and it has been condemned by the great current of modern medical authorities, who believe it to be founded on an ignorant and imperfect view of the disease, many of whom assert that the power of distinguishing right and wrong exists, at least to some extent, among most, if not all, lunatics. The memorials of our jurisprudence are written all over with cases in which those who are now understood to have been insane have been executed as criminals. As previously stated, however, this test is the only one recognized in England, and it is universally recognized in this country. The courts, unfortunately, have not kept abreast of scientific investigations, and the English courts have not been willing to consider insanity as a disease. The existence of such a cerebral disease, however, is earnestly asserted by superintendents in insane hospitals, and other distinguished experts on insanity the world over. Practically all of these distinguished experts agree that the unconsciousness of right and wrong is one thing, and the powerlessness through cerebral defect or disease to do right quite another thing. Section 67. Power of control test. This test is also known as the irresistible impulse test. It is not recognized at all in England, and is rejected by many of the courts of this country. In one English case, however, decided before Macnaghten's case, Lord Denman clearly recognized it, and said that if some controlling disease was in truth the acting power within the accused which he could not resist, then he would not be responsible. Experts on insanity, however, As previously stated, consider it a very important scientific test. Some medical experts state that the true test of insanity is not the knowledge of right and wrong, but whether, in consequence of congenital defect or acquired disease, the power of self-control is absent altogether, or is so far wanting as to render the individual irresponsible. Some eminent jurists and law writers recognize this test, and hold one charged of crime blameless if by reason of insanity, he could not know he was doing wrong, or if he had not the power to resist the temptation to avoid doing wrong. Section 68. Parsons v. State. Justice Somerville, in the leading case which emphatically supports the power of control test, states, the inquiries to be submitted to the jury, then, in every criminal trial where the defense of insanity is interposed are these. 1. Was the defendant at the time of the commission of the alleged crime, as matter of fact, afflicted with a disease of the mind, so as to be either idiotic, or otherwise insane? 2. If such be the case, did he know right from wrong as applied to the particular act in question? If he did not have such knowledge, he is not legally responsible. 3. If he did have such knowledge, he may nevertheless not be legally responsible if the two following conditions concur. A. If, by reason of the duress of such mental disease, he had so far lost the power to choose between the right and wrong, and to avoid doing the act in question, as that his free agency was at the time destroyed. B. And if, at the same time, the alleged crime was so connected with such mental disease, in the relation of cause and effect, as to have been the product of it solely. Section 69. The rule in Illinois. The Supreme Court of Illinois holds that whenever it should appear from the evidence that, at the time of doing the act charged, the prisoner was not of sound mind, but affected with insanity, and such affection was the efficient cause of the act, and that he would not have done the act but for that affection, he ought to be acquitted. But this unsoundness of mind, or affection of insanity, must be of such a degree as to create an uncontrollable impulse to do the act charged, by overriding the reason and judgment, and obliterating the sense of right and wrong as to the particular act done, and depriving the accused of the power of choosing between them. Section 70. The New York Rule. The Penal Code of New York, on the question of insanity, is in harmony with the English rule. It exempts a person only where he was laboring under such a defect of reason as either, 1. Not to know the nature and quality of the act he was doing, or, 2. Not to know that the act was wrong. Section 71. Insanity a question of fact. The existence or non-existence of insanity in a particular case is a question of fact for the jury to determine. It seems, therefore, that courts, in dogmatically denying that such a disease of the mind may exist as may preclude a person from doing what he knows is wrong, usurp the function of the jury. If the tests of insanity are matters of law, the practice of allowing experts to testify what they are should be discontinued. If they are matters of fact, the judge should no longer testify without being sworn as a witness, and showing himself to be qualified to testify as an expert. Section 72. Insane delusion, monomania. A person may be insane as to one or more subjects and sane as to others. An insane delusion may constitute a complete defense to a criminal charge. To do so, it must be connected with the act committed in the relation of cause and effect. According to the English rule, the delusion must be such that, if true, it would constitute a defense to a sane person. As said by the judges, in McNiggton's case, we think he must be considered in the same situation as to responsibility as if the facts with respect to which the delusion exists were real. For example, if under the influence of his delusion he supposes another man to be in the act of attempting to take away his life, and he kills that man, as he supposed, in self-defense, he would be exempt from punishment. If his delusion was that the deceased had inflicted a serious injury to his character and fortune, and he killed him in revenge for such supposed injury, he would be liable to punishment. This rule has been followed since in England, and is also followed by many of the courts of this country. If a man is under an insane delusion that another is attempting his life, and kills him in self-defense, he does not know that he is committing an unnecessary homicide. If a man insanely believes that he has a command from the Almighty to kill, it is difficult to understand how such a man can know it is wrong for him to do it. Like reasoning is applicable to a somnambulist, who imagines, while laboring under his infirmity, that he is being attacked and that it is necessary to kill his adversary to save his own life or prevent great bodily harm. The homicide, in such a case, would not be felonious. On the other hand, where a person labors under the insane delusion that another is trying to marry his mother, and kills him in the belief that such act is necessary to prevent the consummation of the marriage, the slayer is criminally responsible for his act. And where a husband kills his wife, under the insane delusion that for several months she has been putting poison in his food, he is criminally responsible for her death. Also where a convict, while laboring under the insane delusion that a fellow convict has divulged a plan of escape and is spying upon him, kills him, his insane delusion is no defense. An insane delusion which constitutes a defense to a criminal charge is never the result of reasoning and reflection. A man may reason himself into absurd opinions or be persuaded into impracticable schemes or vicious resolutions, but he cannot be reasoned or persuaded into insanity or insane delusions. Section 73. Burden of proof. When a person is charged with the commission of a crime, he is presumed innocent until proved guilty beyond a reasonable doubt. An essential element of guilt is sanity of the accused at the time of the commission of the alleged offense. It follows, therefore, that when insanity is pleaded in defense of a criminal charge, the plea is a denial of an essential element of the crime, and not an affirmative defense in the nature of a plea of confession and avoidance. The burden, therefore, is upon the prosecution to prove the sanity of the accused, like all other facts in issue, beyond reasonable doubt. Many courts erroneously treat the plea of insanity as an affirmative defense, and require the accused to prove his plea by a preponderance of the evidence, considering this defense as in the nature of a plea of confession and avoidance. The burden of proof in its true sense, that is, the duty of establishing one's case, never shifts. The presumption of innocence applies to the defendant, until it is established beyond a reasonable doubt that he not only committed the act, but also committed it with criminal intent. The presumption of sanity, which, standing alone, is sufficient to make a prima facie case upon this point, has no effect whatever upon the question of burden of proof in its true sense. It merely takes the place of evidence, nothing more. The true rule, therefore, as stated by Chief Justice Cooley, is, the prosecution are at liberty to rest upon the presumption of sanity until proof of the contrary condition is given by the defense. But when any evidence is given which tends to overthrow that presumption, the jury are to examine, weigh, and pass upon it with the understanding that although the initiative in presenting the evidence is taken by the defense, the burden of proof upon this part of the case, as well as upon the other, is upon the prosecution to establish the conditions of guilt. Section 74. Somnambulism, where one in his sleep shoots and kills one who attempts to awake him, and there is no motive or intention to injure, and the accused is not conscious of what he is doing, he is not guilty of murder. Section 75. Intoxication. As a general rule, voluntary drunkenness is no defense to a criminal charge. A person can abstain from drunkenness, and if by drinking he brings upon himself a madness, it is held to be voluntary and he is not excused from crimes committed under the influence of such voluntary madness, if previously sane. Section 76. Reasons for rule as to intoxication. The rule that voluntary drunkenness is no defense to a criminal charge is based upon principle and also policy. Its foundation pillars are justice and necessity. The justice of the rule grows out of the fact that every person owes to society, as to himself, the duty of preserving unclouded the priceless endowment of reason, while the necessity of the rule is owing to the fact that without it, life, liberty and property would be placed in serious jeopardy. There is no injustice in holding a person responsible for his acts committed when voluntarily intoxicated. Section 77. Intoxication does not aggravate offense. According to Lord Coke, voluntary drunkenness aggravates the offense, and other writers have sustained this view. From the ethical viewpoint, the statement is correct. From the legal viewpoint, it is not correct. A willful murder, deliberately perpetrated with preconceived malice, cannot be aggravated by drunkenness, nor is that which would be manslaughter in a sober man aggravated into murder if committed by a drunken man. That drunkenness aggravates the offence is not the law either in England or in this country. In some instances, However, it is held to lessen the degree of the offense. Section 78. Exceptions to rule as to intoxication. In some cases voluntary drunkenness may be a complete defense to a criminal charge. If the drunkenness completely negatives the existence of an essential element of the crime, it constitutes a defense. Thus, in the case of an aggravated assault, or larceny, or burglary, the drunkenness of the accused may completely negative the existence of the essential element of specific criminal intent, in which case the drunkenness will constitute a complete defense. This principle is also applicable to the crimes of bribery, perjury, forgery, and conspiracy, in all of which a specific criminal intent to do the act is an essential element of the crime. It is also applicable to the crime of attempting to commit suicide, not as an excuse for the crime but as a material fact bearing on the question whether the accused intended to take his life. Section 79. Effect of delirium tremens. Delirium tremens is an organic mental disease produced by excessive drinking of intoxicating liquor. Though caused by voluntary drunkenness, which is usually no defense to a criminal charge, delirium tremens may constitute a complete defense, even when the crime charged involves only a general criminal intent. This is owing to the fact that the voluntary drunkenness which produces the delirium tremens is the remote, and not the proximate, cause of the crime. The mental aberration, to constitute a defense, must be of a permanent character, and separable from the intoxication which produces it. Mere temporary insanity, which immediately results from voluntary drunkenness, is no defense. The question whether a person, whose defense to a criminal charge is delirium tremens, was, at the time of the commission of the act, under the influence of a fixed insanity, or under a temporary one induced immediately by intoxication, is a fact for the jury to determine, and their verdict upon this point will not be disturbed by a higher court unless it is clearly against the evidence. Section 80. Effect of insanity produced by excessive use of morphine or cocaine. When a person voluntarily uses morphine or cocaine, not as a medicine, but merely to gratify a passion, or to produce intoxication, his responsibility for crime while under its influence is precisely the same as that of a person who becomes drunk by the excessive use of intoxicating liquors. Ordinarily, temporary insanity produced by the excessive use of either or both of these drugs is no defense to a criminal charge. If the crime charged involves specific criminal intent, and the temporary insanity completely negatives the existence of this intent, the insanity necessarily constitutes a defense. If the temporary insanity is produced by the combined excessive use of cocaine, morphine and intoxicating liquors, the criminal responsibility is the same as where the insanity is produced by the excessive use of the drugs alone. Section 81. Drunkenness may negative commission of the act. When a person is upon trial for the commission of a crime, he may show, if he can, that, at the time the alleged offense was committed he was so drunk that he was physically incapable of committing the crime. If a man by voluntary drunkenness renders himself incapable of walking for a limited time, it is just as competent evidence tending to show that he did not walk during the time he was so incapable as though he had been so rendered incapable by paralysis of his limbs from some cause over which he had no control. Section 82. Murder in first degree committed by intoxicated person, manslaughter. In many states, statutes exist which divide murder into degrees. Though voluntary drunkenness is no defense to murder at common law, so far as the element of criminal intent is concerned, it may reduce a homicide from murder in the first degree to murder in the second degree. The statutes usually provide that to constitute murder in the first degree there must exist an actual intent to kill, or deliberation and premeditation. The terms deliberation and premeditation are not synonymous. The former implies reflection, however brief, upon the act before committing it, fixed and determined purposes distinguished from sudden impulse, whereas the latter implies merely previous contrivance or formed design, irrespective of any question of sudden impulse. To constitute murder in the first degree, where deliberation and premeditation are essential, the intention must be deliberated upon, but if the killing is not the instant effect of impulse, if there is hesitation or doubt to overcome, a choice made as the result of thought, however short the struggle between the intention and the act, it is sufficient to characterize the crime as deliberate and premeditated murder. By the weight of authority, evidence of drunkenness of the accused is admissible to negative the existence of deliberation and premeditation and thus show that the homicide is not murder in the first degree. It is to be observed that while fixed insanity produced by habitual drunkenness excuses acts otherwise criminal, one who while sober deliberately resolves to kill another, and gets drunk for the purpose of nerving himself to perform the deed, and kills such person while he is so drunk as to be capable of forming such design, and temporarily insane and unconscious of what he is doing, is still guilty of murder in the first degree. As a general rule, drunkenness will not reduce a homicide from murder to manslaughter, when the same offense, if committed by a sober man, would be murder. A sufficient provocation in the case of a sober man, will reduce a homicide from murder to manslaughter. And exactly the same principle is applicable to a drunken man. Voluntary drunkenness which merely excites the passions of a man and stimulates him to the commission of a homicide, without any provocation, neither reduces the grade of the crime nor mitigates the punishment. Section 83. The rule as to intoxication in Illinois. The Criminal Code of Illinois provides that drunkenness shall not be an excuse for any crime or misdemeanor, unless such drunkenness be occasioned by the fraud, contrivance or force of some other person, for the purpose of causing the perpetration of an offense. Voluntary drunkenness in Illinois may be a complete defense to any crime, an essential element of which is specific criminal intent. It may be a complete defense to a charge of larceny, robbery, burglary or any aggravated assault, as each of these crimes involves a specific intent, and drunkenness may produce a state of mind such as to negative any positive or particular intent. 69 On the other hand, when, without intoxication, the law imputes to an act a criminal intent, as in the case of wanton killing without provocation, drunkenness of the accused may not be shown to disprove such intent. Whether, in a given case, the intoxication of the accused was voluntary or involuntary is always a question of fact for the jury to determine, but the legal effect of voluntary intoxication upon a criminal act is a question of law. Section 84. Intoxication of insane person. Voluntary drunkenness is no excuse for a criminal act. An insane person can become drunk as well as a sane person. His drunkenness, however, will not withdraw from him his shield of insanity. If a man is insane when sober, the fact that he increased the insanity, by the superadded excitement of liquor, makes no difference. An insane person is irresponsible, whether drunk or sober. It is to be observed that it is the original insanity which constitutes a defense, and not the drunkenness. Section 85. Involuntary intoxication. Involuntary drunkenness, resulting from the fraud or stratagem of another, or the negligence of his physician, which renders the person unconscious of right and wrong as to the particular act, constitutes a defense. But drunkenness, which results from satisfying an irresistible appetite which overcomes the will and amounts to a disease, is no excuse for a criminal act, nor is it material on the question of premeditation. It has been held that if a person be subject to a tendency to insanity of which he is ignorant, which is liable to be excited by intoxication, and if, in consequence of intoxication, though voluntary, his mental faculties become excited to diseased action to such an extent that he does not know what he is doing nor why he is doing it, or if conscious of this, he is not conscious of any object in doing it, or if he does not know that what he is doing or the means he is using are adapted or likely to kill, or, though conscious of all these, yet, if the diseased action of his mind has so far overcome or perverted his reason that he does not know that what he is doing is wrong, then he will not be responsible for the intoxication, nor its consequences. This is also Wharton's view. The intoxication in such a case is regarded as involuntary. Section 86. Corporations. It was once doubted whether a corporation could be liable for a crime, but later decisions hold that a corporation is subject to common law indictment. The difficulties about bringing a corporation into court for a crime because of the impossibility of its arrest, have been removed by statute. There are certain crimes involving personal malicious intent which cannot be committed by corporations, but a corporation may be indicted for a breach of duty, and for maintaining a nuisance, keeping a disorderly house, obstructing a highway, libel, violating Sunday laws, selling intoxicating liquors, or for public wrongs generally. Corporations may also be punished for criminal contempts. The method of punishment is by fine, but there can be no punishment of the members unless proceeded against personally. Stockholders are not criminally liable for offenses of officers. Under statutes defining homicide as the killing of one human being by another, a corporation cannot be indicted for manslaughter or murder.